In an era of fierce debates over election integrity and voter access, one courtroom moment has redefined the fight for democratic equality. Today we bring you the gripping story of the Wilson versus State Election Board case, where a young attorney, Jasmine Crockett, faced off against a legendary federal judge and a formidable state legal team. What began as a seemingly routine hearing became a historic battle that could reshape voting rights law across America. Join us for this 60-minute special report on how one woman's preparation and principle challenged the odds and changed history. The federal courtroom fell silent as the bailiff's voice rang out. "All rise." Judge Richard Lyon entered, his stormy expression signaling trouble. Known across legal circles as the Hammer for his fierce questioning and zero tolerance for unprepared attorneys, Lyon had the power to dismantle a case with a single remark. Today, his impatience was palpable, amplified by the high stakes of the Wilson voting rights case. "The Wilson versus State Election Board case," he announced sharply, glaring at the crowded courtroom. "Let's not waste time." The state's attorney, Michael Reynolds, stood confidently, expecting an easy victory. After all, the government rarely lost in cases like this, backed by precedent and a powerhouse legal team. Then Jasmine Crockett rose from her seat. At only 38, Crockett was facing a legendary federal judge in her first major federal case. Most observers believed she didn't stand a chance, not against the state, not against the odds stacked against her, and not for the thousands of minority voters she represented. Crockett approached the podium carrying just a single manila folder. No team of paralegals, no stacks of documents. The opposing counsel smirked, as if the outcome was already decided. Judge Lyon's eyes narrowed. Then Crockett spoke her first words. The entire courtroom fell silent. The judge's face shifted instantly, his eyes locked on her as if she had just revealed something extraordinary. The state's attorney stopped smiling. The gallery whispered in disbelief. "Your Honor," Crockett said firmly, pulling a paper from her folder, "before I proceed, I'd like to present evidence that will completely change what we understand about this case." What she revealed would not only shake the courtroom, but could redefine voting rights law across the United States for years to come, amid ongoing national battles over voter ID laws and election access. If you want to know what was in that folder and how it left the Hammer speechless, don't miss this story. Subscribe and hit the notification bell for more transformative moments in the fight for justice. The Wilson versus State Election Board case emerged from new voter ID laws that blocked nearly 200,000 citizens from casting ballots in the previous election. On paper, these rules appeared neutral, requiring a government-issued photo ID, something most Americans might consider reasonable. But in targeted communities, particularly minority and low-income areas, DMV offices were closed, hours slashed, or relocated far from public transit. For many residents, obtaining an ID meant losing a day's wages, arranging childcare, and traveling over 40 miles each way. The results were devastating. In Westwood County, voter turnout plummeted by 63% after the law took effect. In predominantly minority neighborhoods like Eastern Heights, hundreds of longtime voters were turned away. Elderly citizens who had voted faithfully for decades were told their old IDs were invalid. "I voted in every election since 1964, said 78-year-old veteran James Wilson, standing outside the courthouse. "I fought for this country, paid taxes my whole life, and now they say my VA card doesn't count." That's not right. Wilson became the lead plaintiff after walking 3 miles to vote, only to be denied his ballot. A story that resonated amid national outcries over voter suppression tactics. Judge Richard Lyon was no ordinary federal judge. At 72, he commanded both respect and fear in the legal world. Appointed by President George W. Bush in 2002, Lyon built a reputation as fiercely independent and unpredictable. He once ruled against the NSA's phone surveillance program, calling it almost Orwellian, yet upheld other controversial policies, making him a wild card in politically charged cases. Lawyers who entered his courtroom studied his rulings obsessively, knowing he followed strict legal reasoning over party lines. Law clerks nicknamed him the Hammer for his ability to demolish weak arguments. "If you walk into Judge Lyon's courtroom unprepared," one attorney warned, "you might as well surrender the case." His unmatched recall of case law made bluffing impossible. and many attorneys had been publicly humbled for trying. Across from him stood Jasmine Crockett, whose journey to this moment was extraordinary. Raised in South Detroit by a single mother who worked for the Postal Service, Crockett hustled through school and law school with late-night jobs. Unlike the polished lawyers who typically appeared in federal courts, she built her career defending those who couldn't afford elite representation. Before this voting rights fight, Crockett was known for winning cases that freed wrongfully convicted individuals. In one landmark case, she uncovered hidden police misconduct buried in thousands of files, proving a man's innocence after 12 years in prison. Her reputation for tenacity was well-earned, but few expected her to challenge a judge like Lyon or a legal team as formidable as the state's. The state's legal team, led by Bradley Thompson from one of Washington's most elite firms, boasted over a century of combined courtroom experience. Thompson had argued before the Supreme Court 7 times and never lost a voting rights case. His team submitted a 378-page legal brief dismantling Crockett's arguments. Crockett's filing, by contrast, was just 42 pages long, a fact that fueled skepticism among observers. What no one realized was that Crockett's strategy was unlike anything seen before. While most civil rights attorneys relied on sweeping constitutional arguments or emotional appeals, she spent 6 painstaking months building her case from the ground up, using a data-driven approach that would soon stun the courtroom. She personally visited every affected community, gathering 358 first-hand stories from voters denied ballots. Using census data, she mapped DMV locations against voter demographics, revealing how the regulations disproportionately harmed minority districts. But her most powerful evidence came from thousands of internal emails obtained through Freedom of Information Act requests. For 3 weeks, Crockett worked 18-hour days in her small office, manually reviewing over 11,800 government documents, uncovering something no one, not even the state's attorneys, knew existed. That morning, the courtroom was packed. Civil rights leaders sat beside ordinary citizens whose right to vote hung in the balance. The press section overflowed with national media, sensing this case could become a landmark for voting rights laws in 17 other states. Amid broader national debates over gerrymandering and election integrity, as Judge Richard Lyon entered and called the session to order, no one could have imagined they were about to witness one of the most intense legal battles in recent memory. This was more than a hearing. It was a fight to redefine how American courts interpret voter access and equality in an era of polarized election policies. Have you faced challenges while voting? Were polling places accessible in your community? Or did you encounter long lines, confusing rules, or limited access? Share your story in the comments below. Real voter experiences highlight the impact of these laws on everyday Americans. The air felt electric as the bailiff called for order again. All rise. The United States District Court for the District of Columbia is now in session. The Honorable Judge Richard Lyon presiding. The judge stepped in, his black robe flowing, eyes sharp as he scanned the room. "You may be seated," he said in a deep, commanding tone. "We are here to hear oral arguments in Freedom Access Project versus Brennan Election Commission. Ms. Crockett, you may proceed." Jasmine Crockett walked to the podium with calm confidence, the echo of her heels on the marble floor the only sound. She placed a single binder in front of her but barely touched it. "Thank you, Your Honor," she began, her voice steady. "This case asks a fundamental question. Can a state enforce voting regulations that appear neutral on paper but have discriminatory effects in practice? The Supreme Court has long recognized that the right to vote is the foundation of every other right. When that right is weakened, our democracy suffers." She paused, meeting Judge Lyon's gaze. He leaned forward, listening intently. "The state claims these ID laws prevent voter fraud," she continued. "Yet in the 10 years before these rules took effect, there were only 7 proven cases of in-person voter fraud out of over 14 million votes cast, a fraud rate of just 0.005%. Judge Lyon interjected, as was his habit. "Ms. Crockett, fraud prevention remains a valid state interest regardless of how rare the instances may be. The Supreme Court affirmed this in Crawford v. Marion County. This was where many lawyers would falter. Crockett did not." "You're absolutely right, Your Honor," she said confidently, catching him off guard. Crawford did affirm fraud prevention as a legitimate state concern, but it also introduced a balancing test, weighing the state's interest against the burden imposed on voters. With that, she reached for a folded map. With the court's permission, I'd like to show you something, she said. The judge nodded. Crockett unfolded a large, color-coded map of the state. The red areas represent communities where over 30% of eligible voters lack the required photo ID. The blue dots mark DMV offices where those IDs can be obtained. Notice that in the deepest red zones, mostly minority communities, there are almost no blue dots. Judge Lyon studied the map closely, his brow furrowed. And your point, counselor? My point, Your Honor, she said, is that for voters in these red areas, getting an ID means traveling up to 175 miles round trip. For many without vehicles, that's a 3-hour bus ride each way, if bus service even exists. The few DMV offices in these regions are open only 2 days a week, from 9 a.m. to 4 p.m., hours that make it nearly impossible for working people to visit without losing pay. The state's attorney, Michael Reynolds, rose abruptly. Objection, Your Honor. The inconvenience of travel doesn't rise to a constitutional violation. Judge Lyon turned to him sharply. This is not a trial, counselor. You'll have your turn. Sit down. Then, glancing back at Crockett, he said firmly, Please continue. Crockett gave a respectful nod and pressed forward. Thank you, Your Honor. In Harper v. Virginia Board of Elections, the Supreme Court ruled that no state may impose any cost, direct or indirect, on the right to vote, while the state may not charge a fee for the ID itself. Our economic analysis shows that the real cost, including lost wages, transportation, and obtaining documents like birth certificates, averages $170 per voter. She built her argument deliberately, layering each point like bricks in a wall, anticipating every counter-argument. For nearly 40 minutes, she navigated intricate areas of constitutional law, referencing landmark precedents like Reynolds v. Sims and Bush v. Gore. Judge Lyon, known for relentless hypotheticals, found himself listening more than interrupting. When he did interject, her responses were precise and unflinching, reflecting not just preparation but mastery. The courtroom sensed something extraordinary unfolding. Then came the question that shifted the case's momentum. Judge Lyon leaned forward. Ms. Crockett, let's assume a hypothetical scenario. Suppose the state assigns polling stations based on the last 4 digits of each citizen's social security number. If this system seems neutral, but forces minority voters to travel twice as far as others, with no evidence of intent to discriminate, would that violate the Constitution? The room went silent. It was the kind of complex hypothetical that had trapped many lawyers in Lyon's courtroom. Crockett paused, gathering her thoughts. Your Honor, she replied calmly. That situation mirrors the logic of Yickwo v. Hopkins. In that case, a city ordinance appeared neutral, but disproportionately targeted Chinese-owned businesses. The court struck it down, recognizing that a law can appear neutral, yet produce a discriminatory outcome. She pivoted unexpectedly. Your Honor, your hypothetical highlights something critical about this case. The state argues that as long as race isn't mentioned directly, any level of disparate impact is permissible. That logic contradicts both precedent and principle. Then she surprised everyone. May I approach the bench again? She asked. Judge Lyon, visibly intrigued, nodded. Crockett handed copies of a printed email chain to the judge and opposing counsel. This is an internal communication between the state's election commissioner and the consultant who drafted these ID rules. Please look at page 3. The courtroom buzzed as the judge began reading. The consultant had written, The beauty of using these specific criteria is that they disproportionately affect demographic group A while allowing us full deniability. Since race is never mentioned explicitly. A ripple of shock spread through the gallery. Judge Lyon's eyebrows rose slightly. And how did you obtain this document, Miss Crockett? He asked. Through standard discovery procedures, Your Honor, she replied. It was buried in a section labeled Database Technical Appendices among 50,000 documents turned over by the state. I doubt they realized it was there. The state's attorney, Michael Reynolds, flipped through his copy frantically, his expression draining of color. This case, Crockett continued, isn't only about disparate impact. It's about intentional discrimination disguised as neutrality. The Supreme Court's Arlington Heights framework exists to expose such hidden bias. The atmosphere shifted entirely. What began as a routine hearing now felt like history unfolding. Judge Lyon read the email again, his face tightening in thought. For a long moment, the only sound was the hum of the air conditioning. Finally, he looked up, his tone measured. Miss Crockett, You've presented substantial evidence of intent, but the state argues its regulations survive strict scrutiny because preventing voter fraud is a compelling governmental interest. The tension deepened. This was the final test of her argument. Crockett stood silent for a beat, then replied with quiet authority. Your Honor, for any law to withstand strict scrutiny, it must be narrowly tailored to serve a compelling interest. These ID laws fail that test for 3 reasons. She lifted one finger. First, they are not narrowly tailored. Our analysis shows 94% of the burden falls on minority communities to solve a problem, in-person voter fraud, that statistically doesn't exist. A second finger. Second, there are at least 16 less restrictive alternatives that could achieve the same anti-fraud purpose without disenfranchising lawful voters. These are detailed in our brief. A third finger. And finally, the newly uncovered email proves that fraud prevention was never the real motivation. When the justification is pretextual, strict scrutiny cannot be satisfied. Then came the moment that would dominate headlines. Your Honor, with the court's permission, I'd like to present one final piece of evidence obtained only yesterday. Judge Lyon gave a slow nod. Crockett handed a sealed envelope to the clerk, who brought it to the bench. As the judge opened it, his face shifted from curiosity to disbelief. Inside was a confidential memorandum from the state's Election Security Division, dated 2 weeks before the ID law was announced. It stated, after a comprehensive review, we find no evidence that in-person voter impersonation presents any meaningful threat to election integrity. Resources should be focused on fixing real weaknesses, especially in cybersecurity. A collective gasp spread through the courtroom. Even Judge Lyon's stoic expression softened to astonishment. This completely undermines the state's main claim about why these regulations exist, he said. Yes, Your Honor, Crockett replied confidently. The commission ignored its own security team's report because the real goal was never preventing fraud. The state's attorney stood. Your Honor, we've never seen this document before. We object to its late submission. Judge Lyon gave him a sharp look. Mr. Reynolds, this appears to be your client's own internal memorandum. Are you suggesting the commission withheld this during discovery? Reynolds hesitated. I'd need to check with my client. I suggest you do that immediately, the judge said coldly. This court takes discovery obligations extremely seriously. Turning back to Crockett, Judge Lyon examined her closely. Miss Crockett, he said, his voice echoing through the courtroom. In my 30 years on this bench, I've rarely seen advocacy of this caliber. You've reshaped how this case must be viewed. Legal analysts later noted they had never heard Lyon offer such praise during a hearing. Segment concludes. Part 2 would cover the state's faltering response, Crockett's rebuttal, and the ruling's aftermath, including its impact on national voting rights debates and democratic inclusion.